Good afternoon, ladies and gentlemen. This is Jared Eade. I'm the chair of the California Mortgage Bankers Association Legal Issues Committee, and we are very happy and excited that you all decided to join us this afternoon for a wonderful Legal Issues Committee webinar on hot topics in labor law under California. As we know, California tends not to be the most friendly place to do business when it comes to labor law, and labor law is constantly changing. Whether it be through the legislature or through courts. Today, we've assembled three of California's foremost experts on labor law to give you an update on things that have changed and what you all need to be aware of in dealing with labor law. This is a continuing effort by the CMBA to educate and make sure that its members are well aware of what's going on in California labor. And we're very, very happy to have this presentation brought to you, sponsored by the law firm of Wiener Brodsky. I believe we've got Ken Markinson here to give us a little bit of a preview on what Wiener Brodsky does.
Thank you, Jared. Good afternoon, everyone. This is Ken Markinson. I'm of counsel at Wiener Brodsky Keider, PC. As I think many of you are aware, WBK, as we call ourselves, actively advises on loan originator compensation and related issues, including, of course, federal and state labor laws, as well as other federal and state requirements affecting the mortgage industry. For this reason, and of course, our appreciation of the very high quality of California MBA programs, Wiener Brodsky Keider is very pleased to sponsor these webinars and looks forward in particular to this one. Thanks for the opportunity to speak, and we'll look forward to the event.
Ken, thank you, and again, huge thank you to Wiener Brodsky for sponsoring this and allowing this program to go on and bringing this out there to everyone. This has been a very valiant effort by three, again, experts and foremost legal minds of the California labor industry. First up, we're going to have Natalie Vance. Natalie is the managing shareholder of Klinedinst Sacramento office. Past Natalie, we've got John Cohn, who is of counsel at Griffin LLP. And finally, we'll be hearing from Todd Wulffson, who's the managing partner at Carothers DiSante. We, again, have a great program, so why don't we start off with Natalie here, talking about new case updates, arbitration, and independent contractors. Take it away, Natalie.
Good afternoon. Thank you so much, Jared, and also to Wiener Brodsky for sponsoring this program. I'm going to be talking today about some recent cases that have come down on a couple of hot issues that impact employers in California and essentially throughout the country, because these are two federal cases, one that is applying federal law and one that is applying a recent California case regarding independent contractors. Next slide. The first case that I want to discuss is Lamps Plus versus Gorilla, and this is a case that just came out last month, and it's the United States Supreme Court decision relating to the Federal Arbitration Act and its application to employment agreements. And notably, this case came out of the Ninth Circuit originally. It was a California case in which a putative class member brought a lawsuit against his employer seeking compensation for wage and hour violations for unpaid overtime, not only for himself, but on behalf of all similarly situated employees in the state of California. That lawsuit was originally the defendants in that case, Lamps Plus, who was the employer, sought to move the case to arbitration on an individual basis only. The arbitration agreement between the parties required the employer and employee to arbitrate. And previously, both California and the federal government have allowed for arbitration of individual claims between an employer and an employee, which prohibit class action litigation both in court and in the arbitration forum. Essentially, the United States Supreme Court has previously held that an arbitration agreement that is silent as to whether class claims can be arbitrated does not allow for arbitration of the class action. So if there's an arbitration agreement between an employer and an employee that otherwise meets the procedural conscionability guidelines required, then the employer can mandate an individual arbitration only. That is the dispute between the employee who's complaining for that individual's overtime claims, excluding the entire putative class, and also preventing that person from bringing a class action in court, essentially nullifying a class action remedy for damages associated with unpaid overtime or similar types of class action claims that we see in the employment context. This new case that came down arose out of a Ninth Circuit decision, which essentially tried to get around this rule by holding that a class action claim could be arbitrated even if there was an arbitration agreement between the employer and the employee in a situation where the arbitration agreement was ambiguous as to whether or not class action arbitration was permitted. Next slide. Next slide. So the language in, I'm sorry, can you back up one? I just wanted to show the language that was at issue in the arbitration agreement that was at issue in the Ninth Circuit was held to be ambiguous, stated that arbitration was to be in lieu of any and all lawsuits or other civil proceedings related to arbitration. Essentially, the argument was that it was ambiguous as to whether class claims could be arbitrated because arbitration was in lieu of all civil remedies. Presumably, all civil remedies could be brought in the arbitration proceeding. The court applied a general state rule of contract interpretation, which is that if there's an ambiguity in a contract, meaning it could mean one of two things, then the ambiguity is construed against the drafter. In this case, the drafter being the employer, Lance Plus. And if you construe it against the drafter, then you have to go with the employee's interpretation of the agreement, which was that this essentially allowed for a class action arbitration. This went up to the United States Supreme Court, and the Supreme Court reversed the Ninth Circuit's decision. In other words, it held that the employee could not compel a class action remedy in arbitration. And the reason for that was that prior federal cases have held that there has to be express consent to a class-wide remedy in arbitration because the policies favoring arbitration are a streamlined remedy that is quicker, more efficient, and more cost-effective than a litigation proceeding. So the basis for the decision here was that an ambiguous clause does not provide the express evidence of consent to a class-wide remedy in arbitration, and that any state law rule interpreting an ambiguous agreement against the employer who drafted it was essentially preempted by the Federal Arbitration Act provision that requires consent of parties before a class-wide arbitration remedy can be allowed. So essentially, this is another example of the federal courts upholding arbitration on an individual basis, limiting a employee's class action remedy based on not just silent language, but also vague and ambiguous language. And the takeaway from this is that arbitration agreements can be very useful in helping to protect your company from class action litigation. We highly recommend that you consider having an arbitration agreement with your employees, and also that you make sure that the arbitration complies not only with federal requirements, but also California law with respect to procedural conscionability. But if you make your arbitration agreement subject to the Federal Arbitration Act instead of the California Arbitration Act, you have a much better chance of enforcing a class action waiver or other argument that a class action remedy is not allowed either in the civil court or in the arbitration itself. Now, one caveat is that if you're doing business in California, a class action waiver and arbitration agreement does not preclude an employee from bringing a representative action for penalties under the Private Attorney General Act. And so there is still PAGA claims that can be brought on a representative basis, even if you have a class action waiver and arbitration agreement. Next slide. Moving on to independent contractor classification. Hopefully you all are aware of a case that came down last fall called Dynamex Operations West Inc. versus Superior Court, which essentially adopted a new test to determine whether a putative employee is an employee or an independent contractor. In Dynamex, the court set out an ABC test, and this applies to all cases that are based on violations of wage orders, such as overtime claims and missed meal and rest breaks. The ABC test is A, that in order to show that a putative employee is an independent contractor, the employer must demonstrate first that the worker is free from direction and control of the putative employer or hiring entity, both in contract and in fact. So they look not only at the terms of the agreement between the parties, but at what actually is happening in the workplace. B, the worker must perform work outside the course of the hiring entity's normal business. And C, the worker is customarily engaged in an independent trade, occupation, or business. If any one of these factors is missing, then the putative employee will not be considered an independent contractor, but will be considered an employee who can bring a claim against the hiring entity for violations of wage orders. Next slide. The Ninth Circuit in Vasquez versus JanPro Franchising just came down with a decision which held that Dynamex, the ABC test for wage and hour violations, applies retroactively. Dynamex involved a class action against JanPro, which is a franchisor of a janitorial commercial cleaning company. And there was a summary judgment in the Northern District Court that had been granted many years ago. The case had been pending since 2008 and had been pending on appeal to the Ninth Circuit when the Dynamex decision came out. And the court held ultimately that Dynamex applied retroactively, that there was no departure from established law in Dynamex, that it was essentially a clarification of what the suffer or permit work test required. And because it was just a clarification of existing law, it was retroactive and applies retroactively to any and all cases that are currently pending, any and all claims relating to employment and independent contractor relationships for wage and hour violations up through the date of this decision and going back. So ultimately, it's not a defense to the Dynamex ABC test to say that this employee/independent contractor was working before that Dynamex decision came out. As long as the statute of limitations does not bar the claim, Dynamex will apply. Next slide. Now, I did want to go into this case a little bit because it does provide guidance on the Dynamex test that may be applicable to your industries in evaluating whether someone is an independent contractor or an employee of your company for purposes of wage violations. JanPro, in this case, was a franchisor who organized commercial cleaning franchises. They had master owners who were in turn franchisors to franchisees who were called unit franchisees, who actually performed the work, and the work being janitorial services for commercial businesses. The plaintiffs were two unit franchisees who purchased their franchises through the regional franchisors, but who gave a portion of their profits to the master franchisors, who then gave it up to JanPro. Next. Next. Okay, so the district court initially granted summary judgment relying on a California case, Patterson versus Domino's Pizza, which held that a franchisor could not be liable for a franchisee's sexual harassment of a franchisee's employee, absent evidence that it actually oversaw the day-to-day operations. Essentially, although the district court examined the suffer or permit work language, it was based on a case that preceded Dynamex and used a test that was direction and control of the work only as a basis for evaluating whether the person was an employee or an independent contractor. Next slide. The court not only held that Dynamex applied, but it also provided direction to the district court, essentially telling the court how the court should rule under the Dynamex standard. And so whenever the court reverses and then provides quote-unquote guidance to the lower court, the Court of Appeal is essentially saying, we're sending it back to you to make this decision under this new law, but here's how you should decide it. And essentially, the district court doesn't have much choice in terms of how to evaluate it because the appellate court has already given guidance on how it believes this plays out. And the court ultimately noted that Patterson versus Domino's Pizza does not set the standard for a wage and hour case. That was a sexual harassment case and involved a different standard for evaluating vicarious liability instead of an employee independent contractor analysis for wage and hour violations. Next slide. It also noted that under the ABC test, that there were facts as long as the putative employee was providing a service to the hiring entity even indirectly that could support an employment relationship. Next slide. The court was primarily concerned with prong B, which is the question of whether or not the worker is performing work that is the normal business of the putative employer. And in looking at that, it noted 3 tests which came from other states that will likely be applied in California. The first is whether the work of the employee was necessary or merely incidental to the hiring entity's business. The second is whether the work is continuously performed for the hiring entity. And the third is what business the hiring entity actually proclaims to be in relation to the work that the putative employee is doing. Next slide. We'll just go through these quickly. The first, whether the employee is necessary. There are 2 tests for evaluating this. The first is common sense observation. For example, where a floor measurer is necessary to a carpet retailer's business. However, a highly specialized restoration contractor may not be a key component of a general contractor's work. And then they also do an economic test. And so there was a case where taxi cab operators paid flat fees for medallions, and that was determined to be incidental because the revenues of the putative employer who received the money for the medallions was a flat rate, and it wasn't affected by how much the operators worked or even if they worked at all. And if you contrast that through chauffeurs who leased limousines and paid a percentage of their earnings to the lessor, that would essentially be necessary to the lessor's business because all the profits were derived from the actual work of the driver. Next slide. In the case of the JAMPRO case, ultimately the court noted that the district court should analyze whether JAMPRO's business model relied on continuous cleaning services provided by unit franchisees. And ultimately, it came to the conclusion that because JAMPRO derives its profits and money from the profits of the unit franchisees and advertises itself as a company that provides cleaning services online, likely this test supported an employment relationship. Next slide. As far as the second test, what business the hiring entity proclaims to be, the examples were the operator of a dental offices was an employer of dentists because it advertised dental services. And similarly here, JAMPRO's website described it as a cleaning company. The court essentially rejected JAMPRO's argument that it was in the business of franchising and not in the business of providing actual cleaning services itself, noting that franchising is not itself a business but a method of selling goods and services without acquiring significant distribution costs. And so this has a lot of potential application to any franchise-based business with respect to who may be considered employees for wage and hour claims. Next. Next slide. Okay, so that is the rundown on independent contractors in the JanPro case. It's an example of a case where they thought they had won, they had received summary judgment at the trial court level, but then this new case came out and was applied retroactively and is going to ultimately, if you're reading the tea leaves from the guidance that was provided, change the results and allow now an employment class action against JanPro under the Dynamex decision. All right, John.
Well, thanks, Natalie. Great. And thank you all for having me. In the few minutes I've got allotted here, I'm going to try to cover the issue of workplace investigations, the who, what, where, when, where, why, and how. And let's start with the first slide, which is why. Well, first of all, a workplace investigation is required by the Department of Fair Employment and Housing whenever a harassment claim or a hostile work environment claim is made. Why is that? Well, under the Fair Employment and Housing Act, there's a requirement that employers take all reasonable steps to prevent harassment or discrimination. So the first line in those reasonable steps is undertaking a proper investigation. And often I find that one of the first questions that were asked from the department is, one, did you conduct an investigation? And two, what did your investigation disclose? Second, a proper investigation that's thorough and meaningful usually means that employees see that the company takes complaints seriously. That's a morale issue. Employees want to know that employers are committed to preventing toxic work environments. And third is that a proper investigation can mitigate your liability or provide a defense in a complaint or a lawsuit. Often it's interpreted that a failure to investigate may create an inference of malice, which generally leads to an award of punitive damages. In other words, it's a statement that failure to investigate means that the company just doesn't care about an employee's rights. Not a good thing when you're facing a jury who is trying to determine the relative liabilities of the parties involved. Often a plaintiff will claim that they complained about an incident, but the company just did nothing. And sometimes that complaint can overshadow the merits of the actual underlying incident or the underlying claim. Next slide, please. When does the company, should the company consider conducting an investigation? There's a few opportunities to evaluate. First is when the allegations are clearly, if proven, would violate the law. And usually that's based on incidents of harassment or discrimination out of Title VII or the Fair Employment and Housing Act, and will involve the classic protected categories of race, religion, color, national origin, ancestry, physical and mental disability, medical condition, genetic information, marital status, sex, gender, gender identity, gender expression, age, sexual orientation, pregnancy, childbirth, or related childbirth medical conditions. So it's pretty clear there's a panoply of issues in which an employee can claim that they suffered workplace harassment. Any of those issues become presented, the company should consider an investigation. Also, whenever an employee has retained a lawyer or involves one of the government enforcement agencies, it's a pretty clear indication that the issue has already elevated to a point where the company needs some guidance and some interpretation about the underlying factors, and that starts with a good investigation. And finally, that investigation needs to be initiated promptly. First of all, it creates the perception that the company is committed to fairness and a quality outcome and the truth in the investigation. Secondly, it impacts the quality of the investigation, where the incident is fresh and memories are still ripe. It allows for good acquisition of evidence and information. And finally, if there's some bad behavior involved, it allows the company an opportunity to quickly correct and prevent continuing inappropriate conduct. Next slide, please. Who should conduct these investigations? Well, the company really has two options. They can look to the HR department, their internal mechanism of addressing it. Normally, that is appropriate and fine if you have the company has a qualified investigator in HR who understands the legal issues and is impartial, and the company and the HR department has the appropriate bandwidth to be able to deal with an investigation, meaning the appropriate time and the appropriate resources. Barring that, the opportunities are kind of limited. It's to go outside the company with an external investigator. And under the Business and Professions Code, there really are only two outside investigators that are qualified. Either an attorney investigator, who will likely not be your own attorney because you need an impartial investigator, or a private investigator. And as long as that private investigator is nuanced and sensitive and understands the issues and doesn't model themselves after Inspector Clouseau or Columbo, a private investigator may be appropriate. What are the considerations? If the issues involved are serious or complex, then you probably militate towards going outside of the company for the competency necessary. If the issue involves just a matter of insensitivity, improper comments, or behavior that can be remedied by counseling, that's probably something that is appropriate for HR. The position of the persons involved, that's critical. If the accused wrongdoers are executives or officers or are people that HR report to, that could create an internal problem and a conflict. The amount of time and resources involved. Usually HR is a day job for many people. When a harassment investigation presents itself, there usually isn't a lot of time that's been allotted for that venture. So if the company doesn't have the time in HR to be able to do it, you may need to go outside. The number of witnesses that are involved, who needs to be interviewed and re-interviewed if necessary, and the expertise and competency of the investigator. That's always important. Have they handled issues of this kind in the past? And if so, they may be qualified. If not, you don't often want to train someone with a important investigation. Business and Professions Code outlines, Section 7520 outlines who can perform an outside investigation, and that only permits a licensed private investigator or an outside or legal counsel, which normally means that an outside HR consultant is probably not qualified to conduct an external investigation. Next slide, please. How should it be conducted? We're kind of fortunate. We have, in 2017, the Department of Fair Employment and Housing published their Workplace Harassment Prevention Guide, which gives us a lot of insight as to how that department views the nature and manner in which an investigation should be conducted, and it provides us with some excellent guidance. The guide is structured in sort of a question and answer format, and the first question that is asked is the following. If I receive a report of harassment or other wrongful behavior, what should I do? The department answers the question as follows. You should give it top priority and determine whether the report involves behavior that is serious. If it is not so serious, for example, an employee's discomfort with an offhand comment, then you might be able to resolve the issue by counseling the individual. However, if there are allegations of conduct that, if true, would violate the rules or expectations, you will need to investigate the matter to make a factual determination about what happened. The guide continues and says that your investigation must be conducted in a prompt and timely manner. And the next question in the guide is as follows: how quickly do I need to begin and finish my investigation? The department answers as follows: the investigation should be started and conducted promptly as soon as is feasible. Once begun, it should proceed and conclude quickly. And by explanation, the department says, a prompt investigation assists in stopping harassing behavior, sends a message that the employer takes the complaint seriously, and helps ensure the preservation of evidence. All important aspects of a proper investigation. The investigator needs to conduct interviews. All relevant witnesses need to be interviewed and re-interviewed where necessary. The witness interviews need to follow best practices. Sometimes that requires credibility determinations. What are some of those determinations? Sometimes the investigator needs to question the inherent plausibility of a claim. In other words, could the events have occurred in the manner in which they were claimed to have occurred? Is there a motive to lie based on bias, interest, or any other motive? Is there corroboration? Does a witness corroborate some or all of the allegations? What is the extent of the witness's ability to perceive, recollect, or communicate? What is the manner and nature of testimony? Is there hesitations of speech and evasiveness by the witness? And finally, what is the demeanor of the witness? Are they hostile? Are they angry? Are they defensive? In the frequent he, she type determinations, that is important information for an investigator to know and understand and evaluate. Next, the investigator needs to accumulate all necessary documentation. That's email, that's text, that's personal records, and then finally they need to reach fact conclusions, not legal conclusions, which is an important distinction because there may be a big difference between violating company policy and violating the law, or whether a single incident indicates severe or pervasive or constitutes a legal violation. And finally, the appropriate standard of evaluation needs to be introduced. In other words, the use of the preponderance of evidence standard. In other words, is it more likely than not? Next slide, please. Finally, the company needs to approach it by taking the investigation seriously. Why? Because the government agencies all do. The alphabet soup of government agencies charged with enforcement of employee rights all ask, or at some point in examining a statutory violation, all ask whether the organization engaged in an appropriate investigation and what was the findings. The courts take investigations seriously. I represented an employer who conducted what was quite frankly a terrible internal investigation by a completely unqualified HR consultant. When we got the case, the first thing that the employee's attorney cited was the language of Mendoza versus Western Medical Center. And that is that the lack of a rigorous investigation by defendants is evidence suggesting that defendants did not value the discovery of the truth. That's frankly a difficult standard to overcome. Investigations do matter. And employees take investigations seriously. Employees are a key asset in every company. In some cases, they are our most important asset. They clearly deserve protection. The Department of Fair Employment and Housing calls this buying in from the top. And one of the last statements in their guide is their interpretation that buy-in from the top means that management is a role model of appropriate workplace behavior, understands the policies, walks the walk, and talks the talk. Or as a company executive who I really value once told me, it's not the example of your power that matters, it's the power of your example. Workplace investigations matter. Thanks. Todd?
Thanks, John. And thank you all very much for having me. I'm going to be talking about top things that are getting particularly mortgage lenders in trouble as employers. And we didn't have time for a top 10 list, so I'm going to do kind of a top 5 list. And we're going to focus on things that, particularly in the last several years, have been causing problems for mortgage lenders. Number one is your managers are not using social media properly. As a matter of fact, your managers and your employees are doing things on social media that you're not aware of that is potentially going to get you sued. Some of the top areas is when they're doing recruiting. And there's 2 ways social media can be effective in recruiting. One is to actually place the ads and find the potential applicants, and the other one is the one that causes more problem. It's using social media as kind of a background check. But let's talk about the first one first. If you're posting ads on social media, it's a hell of a lot better than posting ads in a newspaper or things that people don't read anymore. But you've got to keep in mind that social media can be very specific. If you're posting an ad on LinkedIn, for example, you're getting a wide swath of people. If you're posting something on Indeed, you're getting a wide swath of people. I had a client that was looking for an HR director for a mortgage company, and they decided they wanted someone that was wholesome, that was people-oriented, and that would have proper values. So they posted the ad for their HR director on ChristianMingle.com. I'm not kidding. And they're trying to explain to me how I was going to get the right person. I said, no, it's going to get you a Christian person. What about all the other people of all the other religions out there? There are a lot of social media sites that are specific to various cultures, to various religions. If you're going to post on social media, post somewhere where you can get the best bang for your buck. Be careful with Facebook, and Facebook has affinity ads where you can post ads to people that have an affinity with you, your website, your product, whatever, people that work at your company, people that are friends of people at your company. The problem is you may wind up having your ad seen only by a rarefied group of people. It could be just people that are of a certain gender or predominantly a certain age. The affinity ads, and there's still many of the social media sites are kind of coming up with that, are still kind of dangerous. You're better off posting take your job post with your job description, have a reference to your site-controlled job post, put it on LinkedIn, put it on Indeed, put it places like Monster where you think people are going to find it. Tell people how they respond. Tell them specifically, and make it kind of an IQ test. If they want the job, they need to respond to HR. So if they start responding to branch managers or loan officers or things like that, then obviously they're not following the directions, and you probably ignore them. Figure out in advance how you're going to go about selecting people that respond. It's best to have a plan and then see if your plan comes to fruition. So, for example, say, look, we're looking for people that are the typical age, gender, racial orientation breakdown of people in Southern California. And then when you start taking a look at the applicants, you start screening them, doing your paper cuts or whatever, you're narrowing it down. See if the group that you're getting looks like what you expected. If you wind up getting, if you're putting an ad in Los Angeles County and you're getting nothing but white males, you've done something wrong. And keep in mind that if you control the source information, it should be a link back to your site's page, so you can avoid people taking chunks of your ad and reposting it elsewhere and running afoul of, for example, not posting your EEO statement, things like that. If you want to screen applicants by looking at their social media, it's a horrible idea. If you're going to do that, only HR should do it, and HR should do a consistent search on social media just for things that are similar for everyone that's applying. So you want to treat everyone similarly. You do not want to give your managers, for example, the hiring managers, the ability to look at people's social media sites. You absolutely want to tell them that they are not to Google or look at social media sites on any applicant. They're only to consider the information provided by HR. The reason for that is because people are going to spend differing amounts of time on social media sites. My particular experience has been particularly divorced men, middle-aged, spend a whole lot more time on the Facebook pages of female applicants than they do on the male pages. People may spend time looking at Googling people of a certain ethnic background. All these things can lead to horrific problems. So everyone needs to understand only HR does the social media checks. There's no such thing really as it's publicly available information, therefore we thought it was okay. Because again, the amount of time you spend, where you look, how you look, all of those things are going to be used to determine whether or not you or your company had a particular animus toward a certain age group or a certain religious group or a certain gender. And unless you can show that you're doing basically the same type of check for all applicants to screen, it's a problem. Under both the Fair Credit Reporting Act, which is federal, and then California has the Investigative Consumer Credit Reporting Act, you have to provide a person with any negative information that you find that prevented you from hiring them. You may not want to be pulling up the wall posts of their friends on Facebook and saying, well, we didn't hire you because of this picture of you with the beer bong in Palm Springs 2 years ago. You may not want to admit to doing that. So make sure your managers understand that there is no Googling, no background checking, nothing that is done. They're only allowed to consider information provided by either the recruiting department or HR. Next slide, please. Here are some of the social media risks, particularly for lenders. And by the way, if anyone wants a good social media policy that can be customized, feel free to send an email to Dustin, and I'll get one to him that can be disseminated. But I've put all of this into a sample policy. There are a panoply of laws out there that regulate the marketing that mortgage lenders can do. And if you want to know where most of your problems are with respect to your potential marketing and other issues, take a look at your top producers because they have the volume and they're likely doing things that are kind of pushing the edge of the envelope. Here are the types of things, and one of the reasons why you want to have a policy that specifically tells the employees what they can and cannot do. One is if the CFPB or some other regulator comes in, you want to be able to say, look, we've told employees what they can and cannot do social media-wise and on their marketing. You also want to be able to establish that you are routinely going out and searching for the company's name and looking on Google and looking on Facebook and looking on Twitter and Instagram, some of the other sites, to make sure that your employees are not running afoul of your own policy, because the CFPB is going to require that you do that. Any marketing statement that folks put out there obviously goes back and can create liability for the company. Some of the things that your employees are doing that are going to get you sued is they're out there talking about how great your company is and how much better it is than another company, except they're naming that other company. That can be deemed to be defamatory, and the other company may very well sue you for the disparaging statements of your employees. I've had the experience a couple of times where a outside loan officer's Facebook page was so popular it actually started interfering with the search engine optimization of the company. When you searched for the company, you would get her Facebook page because she had such a fantastic referral network and it was so popular, Google thought it was the company's page as opposed to the company's real page. You don't want that to happen. You want to make sure that your marketing and particularly your online presence is controlled by the company and you're doing it in a cohesive way in accordance with what you want the marketing to be. You need to tell the employees in the policy that there are certain trigger words and certain things they can't ever use. They cannot, for example, say anything referring to a fixed mortgage or an adjustable rate mortgage. They can't talk about rates. They can't talk about no points. They can't talk about, we'll pay your closing costs, all those things. That has to be done by the company on an officially sanctioned page. And if one of your employees is doing that on a Facebook page, it can cause problems for them and, more importantly, for your company. Similarly, one of the things, employees that are trying to help oftentimes are the ones that create the most liability unintentionally. An employee gets on there and they decide, oh, well, I'm going to create buzz for my lender. I'm going to get on some blogs and I'm going to get on some various mortgage-related sites and talk about how great the company is. That's fine as long as they're on there disclosing the fact that they work for the company. If, however, they get on a blog site and they're talking about how great ABC Mortgage Company is, and they don't disclose their employee, that's a $10,000 violation under the FTC, the Federal Trade Commission rules. If they're doing that on multiple sites and they're doing it multiple times, that's $10,000 per violation. And guess who gets to sue you for that? It's not just the FTC if they find out about it. It's one of your competitors that finds out that the reason why you're getting more market share in their area is because your employees are out there violating federal law. So not only will they report you to the FTC, but they can also sue you for an unfair competition claim in California, and they can ask that all of the profits derived from your improper marketing be disgorged and given to them. And they also get attorney's fees, and the attorney's fees absolutely can eclipse the damages sought by one of these lawsuits. So it's extremely important to make sure that all of your employees are aware that you have a social media policy, what the rules are regarding what they can and cannot post, and you have to let them know that their off-duty conduct can be just as problematic as their on-duty conduct. And frankly, you don't care whether they're posting something disparaging about a competitor or something in violation of federal law on a Saturday at their home computer, or they're doing it, at the office. One of the things that they need to understand is they can be disciplined for things that occur even off duty. Next slide, please. Another area where managers are going to get you in trouble is this concept, particularly with lenders, this concept of you can't ask for people's salary history. That's really easy when people have a salary or they have an hourly wage. What happens with lenders is, they're having a conversation about, okay, we'd love to have you come over. What's your regular pipeline? I mean, how many loans are you closing per month? Okay, and how do you get paid on that? So, what are you making off those loans? Well, you just ask the person to tell you what their monthly draw is or what their monthly compensation is. You may not have intended to do it, or maybe you did, but either way, you've now violated California law. And by violating California law, you've created a situation where someone can sue you for their attorney's fees and whatever their claim damages are. And it's something where a competitor can sue you claiming you're engaging in unfair competition. Under federal law, you've got to make sure that you're not asking questions that can have a disparate impact on racial groups or on gender, asking people what their prior salary was or trying to divine what their income was can run you afoul of federal law, separate and distinct from California law. Ban the box under California and several other states. There's now 8 states, I believe, that have a ban the box issue. The concept here is you can't ask people that are applying up front whether they've ever been convicted of a criminal conviction. In California, a company that does consumer background checks cannot gather information that's more than 7 years old. However, as an employer, regardless of whether you're in California or anywhere else, you absolutely have to ask the employees at some point, have you ever been convicted of a felony? Have you ever been convicted of a crime involving, sexual misconduct, violence, drugs, or in the mortgage world, I would always ask them anything involving dishonesty or any kind of monetary related crime. The reason why you have to ask that question is because you may very well get a background check that only gives you information that's 7 years old. That doesn't mean that you can't consider information that's older. And if you didn't ask the question, and someone who has, let's say, 3 felony convictions for spousal abuse, but they're all more than 10 years old, comes to work at your company and winds up abusing a female coworker, it's going to be a pretty easy argument for her lawyer to say, look, all you had to do was ask that question. You would have found out that he was relatively unemployable and you wouldn't have hired him. But by not asking the question, it was negligent. All of these issues regarding criminal convictions and stuff, managers need to be told, look, that's not your job. You're not to get into discussion about that. That's HR is going to do that. Just make sure that in whatever state you're in, particularly if you're in California, you can't do a ban the box type question at the outset. What you need to tell people right up front is if you are selected for a job, if you're given a job offer, we're going to do a comprehensive background check, social media check, criminal check, DMV check if you're going to be driving, credit check if it's appropriate. All those things will happen post-offer, pre-employment. just to make sure that they all understand it's going to happen. Many people will self-select right at the outset, but those that don't will get caught up later on. Make sure your managers understand that at some point during the interview process, they're likely to get volunteers. People are going to volunteer all kinds of stuff. They're going to volunteer that they had a criminal conviction that's old. They may volunteer they have a medical condition. They may volunteer that they have some kind of disability. All those things should be handled the same way. Thank you very much for bringing that to my attention. That's not something that I'm going to consider here, but I will make sure I pass that on to HR, and they will communicate with you and resolve any issues that you may have with that. But again, thank you for bringing it to my attention. Now let's get back to the interview questions I have. Next slide, please. This has become a really big one in the Me Too movement, and what I'm talking about here, among other things, is F-bombs in the workplace. Granted, the F word is a very versatile word. It can be used in lots of different ways. The problem is, if it's used in the workplace, people tend to aggrandize its use. They tend to be shocked and appalled, even though they swear all the time in their personal lives. And the problem is, you get into a situation where I couldn't believe that a vice president in a reputable mortgage company would use that kind of language in the workplace. Well, gee, he must have engaged in all of the conduct that she says he engaged in, because he's using that kind of inappropriate language in the workplace. I've had people tell me that the F word is tantamount to a sexual assault. It can create workers' comp claims. It can absolutely, on its own, one time, create a sexual harassment claim. Using it with respect to effing fill in the blanks can be used as discrimination or harassment based on race, gender, orientation, age, you name it. You need to tell your employees, the language they use in the workplace. And I love the example that John used about, they need to set an appropriate example. And the best way to do that is understand that your workplace persona is different than your bar persona, your gym persona, or hanging out in the backyard on the weekend persona. It's really important that your managers do that, because this is an issue that is creating a ton of new lawsuits since the Me Too movement started up a few years ago. Next slide, please. Invading employee privacy is something that managers tend to do without HR or the company's knowledge. You cannot do any kind of monitoring of employees. You can't be looking at where they're going on the internet. You can't be looking at their emails. You can't be looking at if you can get access to their text messages. You can't do any of that unless it is subject to a legitimate business reason and the employee's reasonable expectation of privacy has been reduced. So that applies to off-duty social media conduct. That applies to getting on your employee's computer while they're on leave. You may have a legitimate reason to look at their emails to see if they've got customers they're communicating with. That doesn't give you the right to look at emails with their husband or with their counselor or with their doctor, things like that. Managers need to understand they cannot do any kind of monitoring of employees unless HR or legal gives it their blessing. Next slide, please, which is just kind of a summary of the law. California has a whole lot of specific rules, including you cannot place cameras in the workplace that record audio, period. Can't put any kind of camera, and this is kind of intuitive, in a changing room or a bathroom. The California Constitution provides a separate way to sue, not only for the employees, but this is a really easy area where you can get a class action. A group of employees get together and say, I feel like I've been emotionally distraught. All of us have, and our privacy has been collectively invaded because the company engaged in monitoring the keyboard strokes, looking at our computers, putting the camera in the lunchroom, whatever happened. Don't do any kind of monitoring unless you've gotten the blessing of your internal legal department or outside counsel, and all the monitoring needs to be done and monitored by human resources. Next slide, please, which is the last slide. And one of the last area I'm going to talk about, but one of the areas that's creating a ton of litigation, thankfully enough to put all 4 of my kids through graduate school. I've probably got 30 lawsuits in the firm right now on the issue of marijuana-related claims, and here's what is happening primarily. One, you've got a company policy that says we test applicants and we test for reasonable suspicion for illegal drug use. But the policy hasn't been updated to say, oh, by the way, illegal drug use includes recreational and medical marijuana. So what happens is someone is stoned out of their minds at work. They get taken to the clinic, they get tested, and sure enough, they've got 150 nanograms per milliliter in their blood. They are wasted. However, their argument's going to be, you invaded my privacy because the policy says illegal drugs, and marijuana is legal in California. So you didn't have the right to test that. A really easy fix is just make sure your policy says, for purposes of this policy, an illegal drug includes recreational medical marijuana, any product containing THC. The second area where I'm getting a lot of litigation on this is oftentimes an innocent employee, but sometimes not so innocent, comes to a manager and says, hey, I've got a problem with glaucoma. I've got chemotherapy. I've got insomnia. I'm anxious. I need to self-medicate with marijuana. You're going to accommodate me, right? Well, are they asking, can I be stoned at work? Are they asking, can I leave early on Wednesdays to go smoke a bowl at home? Or are they asking something else? The response of your managers, and they need to be trained, is, thank you for bringing this to my attention. You need to go talk to HR, and HR will explain that to you. HR will then say, look, we will always reasonably accommodate any underlying medical condition. However, you need to understand that it's never a reasonable accommodation for the company to allow you to possess, use, or be under the influence of any illegal drugs at work, including any marijuana, as consistent with our policy. Make sure everyone's trained to that, because this is generating a ton of litigation. Thank you very much. That's the last of my slides.
Excellent. Thank you so much, Todd. I really appreciate that. And Natalie and John, thank you as well. We're running up to our 1 hour time period, so we likely won't be able to get to everyone's questions. Of course, you're all free to reach out to the panelists, and if you'd have any questions that have not been answered today. As a reminder, the presentation will be available for download on the CMBA's website. Any questions you do have, of course, reach out to Dustin or myself or the panelists. In the meantime, let's go ahead and get to one question that we have seen. The question that was asked is, can you speak of California rules and requirements allowing for an employee to work remotely from home? It's an interesting area, especially with California, the way that traffic goes. It seems that's certainly the general direction that things are going in. Any of our panelists have any thoughts on that?
Yeah, this is Todd. I'll jump on it. A couple of issues there. You want to make sure you have a policy that covers how they're going to keep track of their time at home. If they're exempt, it's a non-issue. But in the mortgage industry, most of the employees are probably properly non-exempt. So you want to have a way of monitoring when they're actually working. Second thing is you want to check to make sure that your workers' comp policy will cover them when they're working out of a home office. Sometimes people don't have appropriate homeowners policy or a renter's policy, and your workers' comp will have an exclusion that says we don't cover remote workers because we don't know what you're doing to monitor that. So make sure that's taken care of. And then another big issue is data security. Someone being able to access your computer system and, of course, all that borrower information, and they're downloading it to their home computer. You have no way of knowing if their home computer is secure. You have no way of knowing if they're getting a Trojan horse virus that winds up picking up all this borrower information, because they're not going to sue your employee. They're going to sue your company. So make sure you talk to an IT firm. You can either have a program that's appropriately sandboxed, so it's protected, like Citrix, for example, where you can only log in and log out through the Citrix portal. But if they're going to be downloading information or downloading loan files, particularly something that has personally identifying information on it will allow someone to do identity theft, make sure you've covered potential data breach issue. So wage and hour issues, workers' comp issues, and data breach issues.
Excellent. Thank you, Todd, for that. And again, thank you to all of our panelists, and thank you to everyone who's participated in today's webinar. I think this has been a phenomenal, interesting topic, certainly to tackle, and one that I'm sure goes 10,000 feet deeper than what we've been able to cover today. But it gives a very good overview. So again, thank you so much to Natalie and Todd and John. Again, reach out to Dustin if you have any questions. If you'd like to participate in the Legal Issues Committee more, please reach out to myself or Dustin, and we'll make sure that happens. Thank you to everybody. Have a great day.
Okay, thank you. Bye-bye.
Thanks.